if it's one
Well,
of those days. I hope to
It
make
is
you
one of those
happier.
days. Well, I don't know if you will.
No, I doubt
But
it.
anyway, we're trying to do what's almost impossible, and that's try to compress what we heard in a 1 week span when we did both bills, or 2 weeks, and what you've heard over the break, plus since we've been back in session, as you get ready to vote your bill out.
But we're live, just so you know.
Okay. So we're taking up S-119. The House has made several changes, and we're probably working from a side-by-side that's been prepared by Bryn, and that I believe would be on our committee website. Is that correct?
Correct.
Should be
Okay, and
posted.
Where Representative Lamont, Representative Brad are joining us this morning to go over the changes. We expect Senator Nitka to be arriving shortly as she zooms from the Senate Appropriations Committee to the Senate Judiciary Committee. So go ahead.
All right.
Representative Brad, Representative Lamont.
Yeah, Martin
Lalonde, I'm sorry.
Oh, that's all right. Martin Lalonde from the House Judiciary, South Burlington representative, regarding S-119. Also, I didn't get the memo as far as the dress code for Senate Judiciary, so I apologize that I've.
It's rather informal.
Yeah. I just wanted to give you some background on where we are with this particular draft and in the process that where we've arrived at this draft and where to go from here. As you know, you passed out S-119. We were under a lot of time pressure back in May and June, and we took the advantage of the fact that we had some time during the recess to try to start gathering some more input from affected communities, and so we had 3 public hearings in conjunction with government operations, with the focus being on S-124 and S-119, though many people took the opportunity to expand the conversation and really pointing to many other things that we should be considering as well. We also had a survey that did seek input on S-119 use of force issues, and almost 1,500 individuals responded to that. And then finally, when we came back and started to take testimony, we did reach out specifically. Initially, we know a lot of the law enforcement community who wants to come and testify on these things, but we really made an effort to reach out to members of the BIPOC and disability rights community, and had testimony from 7 different individuals who weighed in from that perspective. And what the off session led to, because I did speak with, in addition to those hearings, I did have conversations. I did speak with folks in the BIPOC and disability rights community. I did also touch base with the AG, had conversations with Julio and David Scheer, and also had conversations with state's attorneys as well. And it led to the draft that we started out with, the proposed amendment. We had testimony.
Martin, yes. Could I just interrupt you for a second? A lot of the folks who may be watching on YouTube may not be familiar with the term BIPOC.
Sure.
Because I've read Layla Saad's book, Me and White Supremacy, but for the record, Black, Indigenous, people of color is what Martin is referring to. Sorry to interrupt you.
No, thank you for that clarification. Absolutely. So we heard from folks from the disability rights community and the BIPOC community. We had testimony from individuals who felt that we had strengthened the bill from their perspective, but also offered some additional ideas. And we put those into place in the version 2.4, which is the last version you all saw, and also tried to address some issues that we understood that you folks raised when you initially saw the amended version, the first amended version that we started out with. So we then had testimony last week from law enforcement, primarily the AG's office, but also some other folks who are endorsing a stronger bill, such as from the ACLU. And this draft is my attempt to find a compromise between what we heard last week and what we had started with. Unfortunately, I don't think that we've reached compromise. Rather than reaching compromise, my initial discussions, and we'll hear more in actual testimony today, is that rather than bringing on the AG and hopefully addressing some of law enforcement's concerns, we haven't brought them on board, and we've lost, I think, the BIPOC and disability rights community who are no longer as, this is initial, I know you haven't heard testimony, you'll have to hear it yourself, but this is what I've heard. And the reason I raise that is I do want, in context and talking about this draft, I want to point out a couple areas that frankly I had issues with putting in, and I'll explain that, but did to try to see if I could find compromise. So with that, I will hit on those couple points right away, because the first one is right up front, and that's the section 1 statewide use of force policy. The concept going in, as I was trying to understand from law enforcement particularly, but others, was to have the statewide standards, statutory standards, and then have certain details and implementation and such worked out in policy.
Martin, can I just ask you which document you're referring to? Because your
Sure.
alternative language is very short, and then Bryn has two here, a draft and an update.
Right. Yeah, the alternative language we'll get to in a bit. I can be looking at the side by side. That's fine if that works best for you as opposed to the bill itself.
The side by side is probably the best document.
Okay.
But I
Great,
would
thank-
add that as you're still drafting this, and you mentioned testimony, we're shutting down.
Right.
I don't know how we're going to get any testimony.
Right.
So this is sort of like having a unicameral legislature. As far as this is it, we're going to get some testimony tomorrow, and because we have two committees and next Friday is the end of the session, I don't know what we're going to do. So, but I have a number of questions. I don't know if you want to, if we can do section by section, might be most helpful.
Sure. Yep. So, I mean, I'll start with section 1. I won't go actually in depth as opposed to just talking the concept behind it. And Bryn certainly in a walkthrough can go more in
as
depth
we
on
go
that.
through it with Bryn later on this morning, maybe we can get a better idea. But I'd love to have just your concept and
Right.
where you're trying to, what you're trying to accomplish.
Well, that was specifically to try to address concerns, particularly of the Attorney General, to have to direct this policy-making procedure for more of the details and such. The problem that I had, and as I looked at this further, and there may be other issues with it, is that that there's a process already started in the executive order that the governor has issued, and how would these two converge? And there's some confusion about how that in fact would occur. So my thought has been in part to, well, let's leave it to that process that's already been kicked off and is already on its way, as opposed to then having this overlay in here, which may cause confusion and hold things up as much as anything. So that was kind of one of my issues with this. The initial input that I've received from the from Wilda White and in the disability rights community is they don't like putting in place this policy procedure here. They don't want to endorse this kind of policy procedure. But that's where they are coming from. My main point is that we can proceed with leaving this to the executive order and the process that was started there, because by putting this in here, I have not necessarily gained any endorsements from anybody. So,
Oh, Representative Lund, it also is in S-124, but not in such detail, but it is in 124. And yesterday we went over 124 with the Commissioner of Public Safety and to find out what the difference was and how they overlap. And there's no problem at all with 124 and the executive order. They work together really well. So I don't think this is necessary at all.
Well,
Right.
I want to ask a question, if I might. Is the Criminal Justice Training Council the right place? And by that, I've heard from a lot of people that it's that should be one place that we should be revamping, and particularly in light of the fact that we're now changing directors. There is nationwide, not just in Vermont, but nationwide questioning of law enforcement training and how it takes place. And I'm not sure that vesting this authority, as we've done in the past with the Criminal Justice Training Council, is the right thing to do. I think we should be re-examining that. And obviously, that's more of a national issue, but it does hit home right here. I've heard, at least in other states, for example, in New York State, even though they banned chokeholds, following examination of the Eric Garner case, they found that the police academy was still, in New York, was still teaching chokeholds with a wink and a nod.
right. And I will certainly get to that issue as well, as one of the other points that I've tried to put in here for compromise, not finding compromise. I'm going to suggest that we no longer have it in here. So,
May I?
I'm sorry, Senator.
I know that this gets very confusing because we have so many bills, but 124 also revamps the training council. It adds many members and from different backgrounds. And I think that, so I realize that all of these kind of are working in parallel
Well,
track.
see, I was referring to the wrong group. I'm not referring to the training council. The academy is what I'm referring to.
Well, the training council is over the academy.
I realize that, but I should have been specific to the academy and not necessarily the training.
So I guess the bottom line is, even though, and I apologize for the way that this, but this is the way it works, I suppose, an iterative process, that even though I'm presenting this as an amendment, I'm not endorsing in this section 1 because, again, it didn't solve anything. And as I think Senator White is pointing out, is only added some confusion, which we don't need at this point with this bill, if we want to get it through. So I'll jump ahead to the next section 2, and that's the standards for law enforcement use of force. And what we have done here relative to the Senate bill is we've expanded it somewhat, though I have cut back a little bit since the last version to make it not just really focused on use of deadly force, which it largely was when it came over from the Senate, to kind of bolster the provisions regarding use of force, which also—
What's the difference between policy and standards, by the way?
Well, I think the main purpose for that change of language was the confusion on law enforcement agency policies and versus a policy and statute. We wanted to make it clear that this is somewhat different than the policies that law enforcement may be promulgating themselves. It's not a critical difference. I think people would understand if we said policy instead of standard, because it's a legislative policy. But I also think that when you say standards, that is more directive, if I will, if I may, if that's the way to put it, that you need to follow these standards, law enforcement. Policy sometimes seems a little weaker to me. So that's kind of why we went with that language.
Okay.
I'm happy to answer particular questions, but I just wanted to, as a general matter, the idea was, there's a couple main points that I'm trying to do in here. I am trying to follow what the current state of case law is. And I really defer to Bryn on that, even though I've looked at case law and other things, but I'm trying to follow the case law, but there are a couple points in here that I think the case law as it's developed is not particularly clear, and I want to make it clear. And you already did in the S-119 that you sent over as passed by the Senate. But I wanted to make it even clearer, and that is the definition of totality of the circumstances. And the way it came over the Senate was it was all facts known to law enforcement, including the conduct of the subject and the law enforcement officer. I wanted to divide that up. I mean, it's the facts known to the law enforcement officer is critical, but separate is that law enforcement officer's conduct. And you had that in there, but I wanted to make it very clear. It's not like what was known to the law enforcement officer as far as that individual's conduct. It's kind of a separate issue. What was the conduct of the law enforcement officer? By, not by his own witnessing of that conduct, but objectively looking at that conduct. So we tried to make that very clear. The other part is making clear, and there's another component in this revised version, and it goes to the additional language that I sent Peggy this morning. It has to do with the treatment of individuals who are suffering from impairment, be it mental health, developmental disability, drugs, etc. That in fact is, at this point, although I'm sure others would argue, at least when it comes to deadly force, that's the issue that we've had in Vermont with respect to deadly force is how the situations have handled individuals who are suffering a mental health crisis. I'm not saying that there isn't biases, other kind of biases, and that excessive force may be influenced by other kind of biases, but that really is why that is specifically pointed out in that provision. So we do have the Senate version did have a bit about use of force and talked about it being proportional. And I really felt that we needed to expand that because that's really only one leg of the stool for use of force and whether it's justified. And the others are whether it was objectively reasonable and necessary. So that standard is now made very clear. But what I did do is I did eliminate, I'm looking for this, where this is. Well, all right, so I'm not going to say what I eliminated from the previous version. I had some additional language about what was necessary and what proportional meant, but that's been eliminated from this draft because probably not necessary. So I would move just to this one additional alternative language that I'm proposing. And it would replace.
Where are you?
Yeah, I'm going to tell you right now. It's at the bottom of page 12. It's at subsection 5.
Law enforcement officer's failure.
Yes.
Is the way it starts. Yeah. Okay.
Yes, and the language that I have proposed, and I need to actually get it in front of me as well. It's on the website. It's more directive as opposed to, and it's more for deterrence than it is accountability, is one way I could put it. That the way it is in the version that you are looking at in the side-by-side is when we're looking at the use of force, we want to have one of the factors is what did the law enforcement do in dealing with somebody who had one of these kind of impairments that affected their conduct. The proposed different language specifically creates a duty that when the law enforcement officer knows that the conduct is a result of one of these conditions, that the officer has to take that information into account in determining what is the appropriate use of force, if any. I think it's stronger language. It's more directive. It's not like after the fact, what did you do? You need to do this. Yeah, maybe it's a matter of semantics, but I think it's important.
Martin, is that the way it's actually written in the statute? I'm looking at the bottom of page 12, and that sentence structure just doesn't read properly to me.
In the alternative language that I separately sent, or what's in paragraph 5 on
this is
page 12 and 13?
Paragraph 5 says a law enforcement officer's failure to take into account a subject's known to the law enforcement officer. I don't know.
Oh yeah,
what,
that would need to be corrected in the language, but I'm proposing that we go to this completely different language, not completely different. It's similar, but it's, I think, stronger language that I sent separately and is not in that document, the side by side at this point.
And well, I'm using two documents. Peggy, is it Bren or Peggy, is there a way to look at the document that Representative Lalonde is referencing?
Representative Lalonde, are you talking about just that paragraph that you sent?
Yes, just the paragraph. Yeah.
Sure,
Could
it's
you
on the website under,
Well, but can you scroll that so we're looking at the same thing?
sure.
It'd be easier. Because I'm in the side by side and I don't want to leave the side by side, go to find another paragraph
Yep, got it.
with limited time available.
Yep, hold on one second, I can share that.
Thank you. Assuming it's relatively similar, will they have time to make those determinations? They're being shot at.
Yeah, I think that again, all of this comes under the use of force provision. I'm looking for it right now in the standards for use of force. I mean, it's at the time, it's the circumstances, the totality of the circumstances, which includes the timing. But I'm looking at.
So, you're going to a domestic disturbance. The perpetrator is holding a hostage and is shooting at the officer.
Right.
Or officers.
Yeah. Right. And in that situation, you are under the, whether you should be using deadly force, and obviously the law enforcement officer at that point to address a situation where there's a threat of death or serious bodily injury is justified in using deadly force.
But if the officer confronts somebody on Church Street in Burlington and they are drunk, then how does the officer deal with that under this?
Right. I mean, they would have to take, I mean, they have various de-escalation techniques. They have different levels of force that can be used, and they have to take into account the individual's impairment when dealing with that. We're just directing, we're not telling them what precisely they should do. That is part of their training and part of what a policy would be underlying all this. But we are saying that if you know that there's this impairment, you need to take it into consideration. And I would point to the Grennan situation. Yeah, they eventually, at the point where they actually had to shoot Mr. Grennan, they had put themselves into that position where at that point was justified because from what I understand. But there were multiple errors from what I have read leading up to that point. That doesn't mean that that it was justified self-defense.
Just let me
But-
say thank you to Representative Grad for joining us. She had to leave to go to her committee.
So I think throughout here, it's all impacted by the totality of the circumstances on whether it was objectively reasonable, necessary, and proportional. And one of those aspects, but we took out those details, is the time frame that we're talking about. And I don't think in any way does this these standards take away the fact that oftentimes law enforcement is going to have to react in a split second, and it doesn't take away their ability to do so when they have to. But it is laying out some requirements, including their conduct leading up to this, that should be considered, not necessarily in charging, in a state's attorney's charging a law enforcement officer with some crime, because that's not all this does. It also sets forth standards that can be separately sued under in a civil action in court. So, I
Mr.
think
Chair,
Yep. Please.
I just wanted to point to the word knows. I see where Representative Lalonde is going with this language. To me, the pivot point is the word knows, because I would think unless you're in a very, very small town,
Yeah.
the officer is not going to know the people when they roll up to the incident. And they might have reason to suspect, i.e. A relative called in the incident and said, this person is going crazy. Is that really, can we fairly say that the officer knows there's a mental condition in that case? Or could the officer argue, well, somebody said that he was going crazy, but I thought that meant he was acting aggressively, not that he had an actual condition. So it seems to me knows is the slippery point there. It could say something if the officer has sufficient reason to suspect, or sufficient information, something like that. But knows is a pretty high standard, I would think.
I agree. Should have known would also be something we
Should have
use
known, yeah.
frequently. For example, the person naked in the streets, and I can't remember what city, when his
And-
family called for help and the police, he started spitting, and then they put a thing over his head and he suffocated.
So specifically, just to flag one case that certainly influenced my thinking on this as well, is a case that is out of the Second Circuit from May of this year, the end of May. It's Chamberlain versus City of White Plains, 960 F 3rd 100. And it was a situation where there were all sorts of opportunities that pretty clear that law enforcement knew that this individual had was suffering from a mental health crisis. And despite that, they did everything to escalate it, it seemed, and led to this individual being shot. Similar to the Grennan, although much more egregious. So in any event, that's really the one. Sorry.
Peggy, you can take that down now. I think we have that. That's the substitute language for the section. Thank you.
So I don't have much more to say about, well, I have one more place I want to point out, and that is with respect to the use of deadly force. I'm looking for the page. Page
Bottom
six,
of page 16.
yeah, it's
Or
on
it
page.
actually is page 16.
Yeah, page 16, the use of deadly force is necessary, that particular language. I do understand that in particular has been a concern of the Attorney General, or at least Julio Thompson. I mean, the bottom line is I think we need to spell out precisely what we need by necessary. And the thing is that the Attorney General Donovan testified that with respect to the use of deadly force, and I think this is just a general understanding, that it has to be the last resort. That is in fact what various policies, including the Burlington policy, and I would say Seattle as well, they make it clear. And of course, it should be the last resort, but I think this language makes that very clear. And again, it doesn't affect, the individual who just, has the gun pointed, the law enforcement officer who has the gun pointed at him, that they are fully justified in using that force. But it would seem that probably not that often when you get to that point is there going to be another option. But if there is, that needs to be followed.
The commissioner testified there's only been 183 state police incidents, use of force. So,
Yeah, I've
did
heard
he testify that with you in your committee too?
I don't think he said that precisely. I think we've gotten the message of what is the problem that you're solving. My response to that is twofold. One is that I certainly think we have some issues in dealing with these situations where there's a mental health crisis, especially since Burlington had a number of policies that they did not follow in the situation with Grennan. And there are other situations where that kind of thing has happened, including in the Montpelier. I don't have testimony about that, but in talking offline with Rory Thibault, there are things that perhaps could have been done differently there. But the other thing is, I'm not looking just at the past. I'm looking, I'm trying to be proactive. I think we're trying to be proactive with this. So I just lost the side by side. My computer just shut off.
Well, I know the feeling.
so I just hit my cord, but at least I didn't hit this one and get knocked off here. So
I think there's one issue that I think we need to, I think I see that, the direction other than the section 1, your changes, looking at the side by side are, I understand them, I think. I'd like to understand on page 20 of the side by side, a law enforcement officer shall not use the right to self-defense pursuant to this common law of justifiable homicide. And then you point to 13 BSA 23053. Isn't that the section that we are repealing? Another bill?
Could you tell me this? I apologize since my
Top of
computer's
page
still
20. Top of page 20. You have a law enforcement officer shall not lose the right to self-defense pursuant to common law or a justifiable homicide defense pursuant to 13 VSA 23053 by the use of deadly force that is in compliance with subsection C4 of this section. I don't understand. I thought that's what we all agreed to repeal in S219.
So it's not a repeal of the justifiable homicide provision. That provision we sunsetted. We would be, instead of repealing it here, we'd get rid of the sunset, and we have different language, which you would find on, if I had the side by side, I'll let Bryn point out where that alternative language is.
Is that on page 22 where prohibited restraint means the use of any maneuver or person?
No, it's on the updated side by side that I sent 10 minutes before the hearing started.
Yeah.
It's on page 24. That was the section that was inadvertently dropped from the first side by side I sent you. So it's section 5 of the House proposal of amendment. So it rewrites that justifiable homicide statute. And I think that was actually, that language was included in the previous draft you looked at, 2.4.
So on page 22 starts, a law enforcement officer acting in the officer's capacity as a law enforcement agent, enforcement may use a prohibited restraint if the use of deadly force is justified. Is that what we're talking?
No, so that is the prohibited restraint crime that was established in 219. So there is also additional language in that prohibited restraint crime. But in addition, the justifiable homicide statute is amended rather than repealed, and that is in section 5.
So what did we do with the new law that we passed that's effective October 1st? Is that repealed too?
It's repealed, but it's reinstated in this amendment. So it's
So
reinstated.
we're taking what we passed in S219 and repealing it and reinstating something else. Is that correct?
It's reinstated largely as it passed in 219 with the addition of that subsection C on page 22 and a change to the definition of prohibited restraint.
I think Senator Baruth has either a comment or a question, and Senator White has either a comment or a question.
More a comment. I believe I understand what this draft is doing with regard to 219. Speaking for myself, I don't like what it does with 219 because it adds again that permissive language that we saw in the first draft.
Yep.
So what I would suggest is a possibility is that we here it repeals the sunset for that part of 219. I like that, but I would if we struck out the part that modifies 219, then it works for me because it seems schizophrenic where in one place in the bill it says a prohibited restraint may not be used for any reason. And then in this section, it says it may be used. And I don't see how anybody can expect clarity if the bill says two diametrically opposed things. So I suggest going back to our language on 219,
Well,
keeping the repeal of the sunset.
I would go back to, I just want to make clear to both Representative Lalonde and this committee, my intent is to do one of three things. Assuming the House passes a bill, we would either concur, we would concur with proposal of amendment, which would be amendments, if this passes the House, which would be amendments that we would agree upon in here in Senate Judiciary, or we would ask for a committee of conference. Those are three choices. Obviously, as late a date as we're talking about and with expected adjournment on the 25th, requesting a committee conference could be problematic. So probably the preference would be, if there are sections that we just can't agree with, would be concur with further proposal of amendment.
So yes. I
And then
agree.
Senator White has, did you want to comment on Senator Bruce, Representative Lalonde?
I did, if unless Senator White is going to comment, I'd like to comment on what Senator Bruce just said.
Well,
yes.
I was going to throw in yet another option, a fourth option here, which is not to do this bill at all right now. I have to admit, and maybe I just don't understand what's going on, but I don't even have a clear understanding of what it is the House proposal is, because it was in a side-by-side, but then we heard this morning that all of section 1 is out and the other section has been somewhat changed now. So I don't have a clear understanding, and I don't know if this has actually passed the House Judiciary or if there will be additional changes potentially. I don't think we have time to address this bill properly this year at all. And so I'm offering a fourth alternative, which is not to do this bill at all, to have 219 as we passed it and take this up next year. That's my, I am
Well,
very.
that is another alternative, but fortunately, we don't have to make that decision next week.
No, we don't, but I'm, because I don't even have a clear understanding of what it is the House is proposing, because they haven't actually proposed it yet.
Sure.
Understood.
And that's why this is a very strange way of doing business. And as
You're correct.
said,
It would be that the fourth choice would be to recommit the bill to the Senate Judiciary Committee, if it makes it over.
Sure. To Senator Bruce's point, that this is another provision that was my apparently futile attempt at trying to find compromise. But the language that we have in there modifying section, the 219, S219 crime, prohibited restraint crime, that language just makes explicit what is already available to law enforcement that may have used a chokehold and in a situation where they're grappling and it is a life and death situation and deadly force would otherwise be justified. I tried to make that explicit in here to hopefully bring along more of law enforcement, but taking it out doesn't really change anything, frankly. They still would have the justifiable homicide statute, which we are amending, would amend in this if it gets all the way through to Senator White's point, and the common law defenses are there as well. So I'm going to be suggesting when the House is discussing this, and hopefully we'll have a vote, and I believe we will have a vote, that section is going to be taken out, the modification to 219. Again, that's what I'm going to propose, but of course I'm only one of 11 members there, but I do feel that we're going to have support. I know, because this in part also goes, it approaches, from what I understand, what the Senate has done, and it approaches what the BIPOC and disability rights community has weighed in, and it's going back in that direction. And I do know that, I'm pretty sure there's a majority in our committee that would endorse that approach. So the bottom line, as far as this draft and where I perceive it may end up at the end of the day with House Judiciary, but I'm not the master of ceremonies over there and can't force this issue, of course. But I would say that we're going to, at least where I'm going to be, is going to be eliminating section 1, having that alternative language that I showed you for that subsection B5, and eliminating what is section 3. And the rest of the bill would be as it is revised here. At least that's certainly what I hope that at the end of the day is, or the end of this week, is something that we would vote on. But of course, there is still testimony to be taken this morning.
Right.
And there is a suggestion of some language that the Department of Corrections is wanting to have somewhere, and this seems to be the right bill to put it. I don't have any details of what that is right now, because I think that's being presented to our committee right now.
Yep. Okay. I appreciate you taking the time with us, and that I would say this is still, as far as the House Judiciary goes, I think it'd be correct to say this is still a work in progress, and we don't know what it'll look like the end of this week as it gets voted on, hopefully by the House rather quickly.
Right.
I'm worried about, we've been trying to work a way to respond to this, just as you were trying to find a way to respond to S219 earlier this session while we were taking our time working on it. And that's why we split the two bills. We started as one bill and then split them in half. I appreciate you taking the time with us. I think I don't know what we will do. I'm really, I'm from a national perspective, from what I can learn, the police academies are one of the areas in need of rehabilitation. That's the way I can put it. And secondarily, I think that in many cases, what frustrates the communities is when a police officer acts inappropriately. The ability, when it's clear, the ability to remove that police officer is difficult. But what we saw in so many cases recently is police officers actually fired for misconduct. And do we have that ability in Vermont? Those are two areas where I see the public really being concerned. Obviously, you all know more about what's going on in Burlington than I do. But I do know it's frustrating to, for example, in the Woodside case, we have 11 staff members on paid administrative leave while we figure out what they did, out of 30 that were working there. So when people say, well, why did you support temporarily closing Woodside? My answer is that they had 11 people. So and that I think the general public gets frustrated with when it's clear. And so, in the Minneapolis case, they were immediately fired. I don't know if you can do that in Vermont. So those are two areas where I see the public calling for rapid change.
Yeah, I think there's a lot of work to be done next biennium. Hopefully we can get this small piece of the work done before we leave. And I understand, if there are, as you look at this and as you're talking to folks today, if there are other areas that jump out that, you just won't be able to concur with, just please through Bryn or directly let us know.
Well, I think Senator Ruth expressed, Mike, the concerns of the majority of this committee in terms of that section.
At least this member of House Judiciary is on board with those items that we've talked about today. So,
yeah.
Thank you so much. I appreciate your time. I'm going to jump over to the other room.
I know what it's like going from one Zoom to the next.
All right. Thank you.
Thank you, Martin.
Bye.
Bryn, Peggy, can we take a 3 or 4 minute break and then come back to Bryn walking us through these in more detail, forgetting the sections that he's already said are going to drop.
Sure.
So why don't we take a 3-minute pause?
Mute and take your
Boo boo. What you doing? What you doing, big girl?
Senator Booth, I'm going to mute you, okay?
Hope he's talking to a dog.
I know.
I am talking to my dog.
All right, I won't mute you.
She's the dog most versed in education issues in the state. She, whenever I sit down for a Zoom call, she parks herself right behind me. Joe, do you have a dog?
I have a cat.
A cat.
Had a dog for many years, but then my dog died, and shortly thereafter, my daughter came home with a cat that had been thrown out of a car.
Oh,
And we nursed it to health and sort of became attached to it, but she's now 13 years old, has suddenly decided that she is very picky about what she eats. For years and years, she had the same food, and then all of a sudden she stopped eating it. So we've been giving her everything from real tuna fish to real steak, real eggs, and turkey and chicken. And I'm one day she'll eat the tuna fish like it's going out of style, and the next day she won't touch it.
you know, we're on YouTube Live, just as long as you guys know, I have no problem. I just want to make sure you know.
Actually, Joe, what happened is she got old and smart enough to realize if she went on a hunger strike, you'd give her the real tuna and the steak. And
Yep. Well, she knows she can get that smorgasbord if she just is a little more persnickety.
yeah,
And we may be live if there's anybody out there that knows, is that a sign that my cat is getting ready to kick the can?
Well, I thought you were talking about me.
persnickety.
I want the real stuff.
Yep.
Jeanette Banshee White.
I'm so sick of dealing with this. God, this stuff is.
What are you sick of, Dick?
Oh, if
We're
one
live,
group
just so you know.
gets something out of appropriations, the other group thinks they need the same thing. You don't understand. Oh, well. So comes, I wanted to be on appropriations, and I love being on appropriations.
Are you
This
thinking,
time of year,
you
remotely.
thinking about the text I sent to you about 10 minutes ago?
Oh, I know, everybody in Windsor County's upset.
Right, but got even a stranger one from someone else.
I think I've seen that one.
Okay.
And then I got a plead with Senator Baruth.
What is, you were referring to some education issue?
Yes. The
What?
ADM for those communities that are going to see an increase in student population.
No, it just says you can't have less than last year. Doesn't preclude you getting more.
Right. So what happens?
Then they
to
just
those
get
communities?
more in their ADM.
When does the school count occur?
That's the problem. Their budgets were based upon a population back in March, and that's what anyway, appropriations will be asking you that.
Okay. Yeah, I thought that we had it written in such a way that nobody would be disadvantaged by the pandemic. But because some communities are getting an increase of people essentially fleeing the pandemic elsewhere.
Yep.
So we don't want to disadvantage them. So it just set last year's ADM as a floor that you couldn't go below, but you could go above.
And on what date does the school count occur?
I want to say it's October, sometime in October.
Uh-huh.
But if there's modification necessary there, it's what we were trying to do is pretty simple. Just make sure nobody suffers from, having a chunk of students start homeschooling, for instance.
Right.
So.
Dick and Jeanette, I don't know if you got the same email I did from CAX.
Nope.
No, I haven't gotten an email. Well, I may have gotten an email. I haven't checked my email in the last half hour. They want a quote on the S-54.
Yep. But we're looking for it this morning. I think we're occupied.
I think we are. So I saw there was maybe Bryn, this may be premature to even be looking at the House version side by side, since the side by side is changing as we speak.
Can I don't know if this is the appropriate place to put in a plug for Jeanette's suggestion here. I'm really concerned about this attempt to try to get something out on this before we break. To me, this is probably the most important piece of legislation I could imagine this session, when you're dealing directly with life and death issues. And trying to balance those life and death decisions without us taking the appropriate testimony. I know we've done piecemeal testimony on this, but I really don't feel comfortable, especially given this is a work in progress on the House side, to believe we're going to have the opportunity to take all the testimony we need prior to adjournment. And I know I may be speaking due to the pressure I'm feeling from the court system right now. And if I panned around my office, you'd see stacks of files waiting for attention. But the bottom line is, this is such an important piece of legislation. I caught about 1/3 of the testimony from the House watching YouTube versions. And the last person that was speaking that I saw was Wilda White, who was saying, please don't rush this, do it right. And if she's telling them that, we haven't had that same discussion. And I'm really nervous. I think I'm happy that the House is taking testimony, trying to flesh this out. It probably will be a much better piece of legislation to look at the end of the day when they're done with it. But I'm nervous about whether we are going to have the time to try to properly respond. And I'm going to plug Jeanette again and say I would prefer that we just simply have it recommitted to the Senate and call it a day.
Well,
May
luckily
I just add something?
yeah, but yes, okay.
I think that one of the things that I've seen in this committee is that when there is an issue like this, we have very thoughtful and serious discussions among the five of us with witnesses and legislative counsel. And I don't think it's possible to have that same depth of conversation and discussion and thoughtfulness in this format. And this is one of those issues that I really think needs to have us be sitting across the table from each other and talking. So.
Okay.
Philip has a question.
Well, I guess it depends on, we obviously don't have the time to get the testimony from everybody that's going to testify. But I think that we at least should wait before we make a decision until we see what they've done to our bill. Philip?
I agree, Dick, to waiting. I feel some of the concerns that Joe and Jeanette are expressing. I do see a path, given what Martin said that his committee was prepared to throw out of the bill. I do see a path to a bill that I could support. For me, what it comes down to is how quickly does House Judiciary work. So if we don't get the bill until 24 hours from the end, I think that speaks for
Yeah.
itself.
Yep.
So, but if we have, sufficient time at the end to deal intelligently with it, then I would be for proceeding.
Okay, I will send a message to Tim. I believe they're planning on voting it out today or tomorrow. Is that correct, Bryn?
I have not heard that, so I don't know.
Okay.
I did hear that from Martin, that his goal was today with a fallback of tomorrow.
Looking at the side by side, and we'll get an updated side by side once they make a final decision. We could go through that and determine whether or not we're how close we are.
Mhm.
Do we have, I still don't, I mean, I'm gonna now ignore section 1 since he said he's taken it out. So going directly to page 6, where there's the first, we just did deadly force and they used any force, is that correct?
And can you say the section, Dick? Because I don't have 12 pages. I have it
Okay,
more condensed.
section 1, it's our section 1, their section 2. You all right? Okay. It starts on, it says statewide policy. Ours was law enforcement use of deadly force. Theirs are standards for law enforcement use of force. And then they added that force means physical coercion employed by a law enforcement officer to compel a person's compliance with the officer's instructions. So the two changes there. One is they define force. Then they agree with us on deadly force and what that means. It's the same as our version. So the differences are they use standards for law enforcement. We use policy. We restricted to deadly. They go to all force. Right?
Yep, that's a good characterization of the differences on the first couple pages there.
So Joe, questions or comments?
Yeah, Bryn, the difference simply being that they've defined force, expanding the title, if you will, beyond what we had limited to deadly. Is there any place else in this bill that something less than deadly force has actually been changed as a result of that definition change?
Let's see if, I'm not sure I understand the question. They do expand subsection B, which is all about the use of force, not necessarily about the use of deadly force.
Okay. I guess that answers my question
Then later on,
significantly expanded that portion of the standards.
then.
Later on,
Thanks.
number item 4, prohibited restraint means, and we used the term may prevent, and they struck out the may prevent. I don't think I like that.
And they do
because-
that in several places in this amendment, because for consistency's sake, you remember S219 created that definition of prohibited restraint in Title 20 and in the new crime.
Okay,
They've changed it in 3 places, including here.
okay.
They've changed it to align with what we passed in 219?
No, they've changed it so it doesn't include the word may. So it's any maneuver that prevents or hinders breathing, rather than may prevent or hinder breathing.
And what did 219 say?
Hey,
219 said may prevent, may prevent, hinder breathing. It was the same as what you've got in your
Okay.
version of 119.
Okay.
That, what does that do practically?
I think it limits it limits the definition of what a prohibited restraint is.
So that prevents the hinders the breathing, not may prevent. So I could argue that what I just did when I grabbed somebody by the neck, I didn't intend to.
Yeah, I think it makes as a part of the analysis whether or not the maneuver actually did hinder their breathing or blood flow.
May I ask a question?
So even though we know that grabbing by the neck may hinder, no, let me just finish so I understand. We know that that may hinder. Under our version, grabbing the neck would be not okay. Under their version, it might be okay if it didn't hinder. Is that correct?
Correct.
Thank you, Jeanette.
So I guess my question is more procedural. If in 219, it says that it may prevent, and then if the House version passed on 119, wouldn't we have two conflicting statutes here? One
Not
in
ultimately, because what the House does in their amendment is to change that definition everywhere where it passed in 219. So it's, for example, in section 3, we amend the prohibited restraint crime. In section 4, we amend the definition in Title 20.
Okay, thank you.
Basically, they're using the fact that the effective date was October 1st, and they're planning to get this passed before the effective date.
Dick, if we work backwards from what Martin said he was willing to do, he said he was willing to get rid of section 3, which deals with 219. That implies directly that he'd be willing to get rid of these changes to the definition, because otherwise, as Jeanette said, we would have conflicting definitions. So I read him as saying that they would be willing to get rid of all the changes, including these definitional changes.
Okay. But I guess those would be things that we should communicate through Bryn with, if you could keep track of them, Bryn, so that we can communicate with House Judiciary.
So I'm hearing that this committee doesn't agree with the change to the definition of prohibited restraint.
Yes. So then they go on to all of that regarding the physical, the language barrier, alcohol impairment, etc.
Correct. The totality of the circumstances definition.
Yep.
Right. So specifically includes those factors that may interfere with a person's inability to comply with law enforcement commands.
Any comments on that? I don't have a problem with that, actually.
That looks good to me.
So
Fine.
then we're now going to, we're still in the same section, Alice.
Okay, yes, I'm following you.
So the
There's a
next
change
one-
on the bottom of page 10, or to achieve any other lawful law enforcement objective.
So this language, B2, this is where the House version uses the language that the Senate version had in B5. And that was sort of the one subdivision in the Senate version that addressed use of force generally, not just use of deadly force. So they've sort of adapted your language and moved it up to B2. So what this language in yellow does, the new clause there at the end, is added to the standard for law enforcement use of force. And essentially it expands the circumstances under which law enforcement may use reasonable, necessary, and proportional force. So the Senate version provided that law enforcement can use force if they have reasonable cause to believe a person to be arrested has committed a crime. So what this does is it says law enforcement may use force if it complies with these standards, if to achieve any other lawful law enforcement objective, not just to arrest a person or detain a person who the law enforcement officer has reason to believe that committed a crime. Does that make sense?
Okay. So if now we're no longer talking about deadly force. So if there's a protest, peaceful protest, and the people are in the street and they're instructed to leave the street, would this allow them to use force in order to remove them from the street?
I think arguably, yes, it would. That language, any other lawful law enforcement objective is, I think, pretty broad. It essentially is drafted to include any purpose that law enforcement have that is lawful. So clearing people from a street to me would probably be a lawful objective of law enforcement.
I would star that with a problematic.
Okay.
But this is referring to any use of force, right? Not deadly.
Yeah, I mean, deadly force, we restricted ourselves to deadly force. If we were to agree with them at some point that any use of force, this is allowing them to determine what is a lawful enforcement objective. Well, you saw what happened in Washington, D.C. at Lafayette Park when the president protest is removed. And so allegedly he would have his photo op in front of the church.
I just am thinking that if we're talking about any force at all, that there are times when law enforcement uses force, because force can mean just compliant handcuffing. That is a use of force. So if you have a DV situation, for example, where, they haven't determined yet whether a crime has been committed, but you have a couple violent people here and they need to cuff them in order to restrain them, that could be another law enforcement objective to stop the fighting that's going on. But so if you're talking about any force at all, as opposed to deadly force.
Okay. Next is, this is the section, subsection 4. Whether the decision by the law enforcement officer to use force was objectively reasonable shall be evaluated from the perspective of a reasonable officer in the same situation based on the totality of the circumstances. And we had language, they have language, and maybe you could help us understand what the difference is. This is on pages 11 and 12.
Sure. So bottom of page 11, top of page 12, the House added an additional sentence to this subsection that adds that the officer's failure to use feasible and reasonable alternatives to force is a factor to be considered in determining whether or not that use of force was objectively reasonable. So it essentially, as Representative Lalonde was saying earlier, it adds a burden on law enforcement to consider other reasonable alternatives to the use of force if feasible, because that will be a factor to consider when considering whether or not their use of force was reasonable.
I actually like that addition because you remember in one of their earlier drafts, they had a whole thing about you must use de-escalation policies.
Yep.
And that was too specific, and it seemed like it produced a lot of confusion. This is a way at getting at the same thing, that retroactively a decision will be made based on whether they availed themselves of other options.
Okay, so now you have a note here that says the Senate version of B5 is the House version of B2.
Yep, I
Help
just,
me with,
yeah, I just placed that note there because you see on the Senate side, the left side, subdivision 5 is in highlight, and you don't see anything next to it. And I'm just making a note that the House did use that language. They just moved it up to B2, and that
okay,
was the language we just talked about when law enforcement is authorized to use force. So they expanded it in their version to include any lawful law enforcement objective.
and then they add in language in 5 is all new language, is that correct?
That's correct. And this is also the area where Representative Lalonde presented some substitute language that he was going to present
Right.
to the committee this morning.
Bryn, is there a word or two or a line missing there?
I think that Senator Benning pointed this out earlier. It looks like the word conduct was dropped. That happens sometimes with these tables,
Okay.
unfortunately, at the page break. Sometimes we lose a couple words. But I did want to point out that you may not want to talk about the language specifically because Representative Lalonde indicated he wanted to replace it with something else. So we can talk about his replacement language, which you looked at on the screen. Peggy put it on the screen. And that was the language that created a duty when law enforcement knows that a subject's conduct is due to some impairment or other factor outside the subject's control. It puts that duty on using that information. Law enforcement has to use that information that they knew in deciding whether or not to use force. And again, Senator Bruce had pointed out that that word "know" is a key word because law enforcement had to have known those facts in order to have the burden of using that information and deciding whether or not to use force.
Yeah, I just think it's very tough to prove that somebody knew something, which, as Dick pointed out, is why we go with should have known, because you just can't get inside somebody's head that way.
Would you add that comment, known, should have been, should have known? Because
Okay. Do you want me to keep going?
yep, now we're at section, I'm trying to see, we're at C, use of deadly force. And C1 on page 15, and I don't know if Alice is able
Yeah,
to follow.
I'm following you.
Okay, they took out the words, the officer reasonably believes. Is that correct?
Yep, they did take that out. There was some conversation that was just redundant language because we're also referring to the totality of the circumstances, which also refers to the officer's reasonable belief. So I don't think it necessarily fundamentally changes this language to take out those words. Other than that, that C1, that is the standard for use of deadly force, and that language hasn't changed at all.
And
But
then,
you turn to page 16, you have some new language in subdivision 2.
Yep.
And that's the explanation of what the word necessary means in the context of the use of deadly force standard.
mhm.
Subdivision 3 is also new language that says that law enforcement has to stop using deadly force as soon as the subject surrenders or no longer poses an imminent danger of death or serious bodily injury.
I'm thinking there about, you see videos of people being tased,
Mhm.
and when they tase them, they spasm, and for obvious reasons, they throw their arms and they yell, and sometimes officers will retroactively claim that that's why they continued to tase them, is because they didn't remain motionless in order to be cuffed, but they're being, electricity is being shot through their body. So when I look at that definition, I see when the subject surrenders, or no longer poses an imminent danger of death or serious bodily injury. I have some doubt about, you know, in an earlier version, I think they also included prohibited restraints, which seemed to me to indicate that you could choke somebody until they went unconscious, which in the case of the Minneapolis officer, that's what he was actually attempting to do via his training. So I think it's probably okay here, but I wonder if there's, you know, as soon as the subject surrenders or no longer poses an imminent danger, I just wonder if there's a more specific or clearer, I guess it's okay.
Well, you're trying to bring the person under control. Once
Yeah.
the person's under control, then it should be over.
Yeah.
I mean, that's,
This is kind of one of those areas I'd like to get some more testimony on, though. When you're actually in the process of pulling out a gun to stop some use of deadly force by the suspect, and you pull the trigger, lots of times you pull that trigger more than once. Somewhere in that series of trigger pulls, there could be an argument made that the person was no longer in imminent danger of death or serious bodily injury. I mean, the officer was no longer subject to that.
right.
Do we now enter into an area that splits hairs? It's just one of the
Possible.
reasons I'd like to have some more testimony from the other side to talk about it.
What's the other side? Law enforcement?
Well, certainly law enforcement. I don't know about you guys, but I'm getting emails from Beth Novotny about their concerns and the inability to have had testimony yet. So I'm somewhat.
I have not heard from Beth. I suppose by saying that I will, but I don't believe I have.
I know that right now she's watching the House Judiciary Committee and their conversations about this entire bill. So I'm believing that we'll all be hearing from her eventually, but it just tells me that there's more information out there that we ought to be thinking about.
Peggy, do you want to contact Beth and see if she's available for tomorrow morning at some point?
Yes, I can. My screen froze, so I missed some of that, but Beth Devotney, I heard.
Yes, she represents the Vermont Police Association.
And on S119, should I send her as well as Marshall and Terrence all the documents from today?
Yes. Well, the hard part is they keep changing. So
Yeah.
I think for Marshall and Terry, they're going to be basically talking about the national effort and what's going on. And also they have more knowledge of Seattle than Marshall lives in Seattle. And I believe he's been talking with folks from that area, police department and so forth. So, which in large part, some of these changes have been based upon Seattle's policies. But they are policies, and I want to point out that they are, as I understand it, this is one of the questions that I'll have for them, is the difference between Washington state law and the policies that have been implemented in Seattle. And so you may have might have different policies in Tacoma than you have in Seattle, but there's a state law that I believe is the minimum. That's one of the things I wanted to hear from them and understand. So you may want to look at what is Washington done.
Okay, Zoom kicked me off for like 5 minutes, but what I'll do is I'll go back and listen to the YouTube so I can hear what you wanted. I don't want to take your
Well,
time.
it's just basically to have Beth Novotny testify regarding the house changes.
Okay. Regarding house changes. Okay. And if there's anything else you want me to let Marshall and Terrence know, just send me an email.
I think you're fine. I
Okay.
think they're fine with what we've given them so far.
Okay. That was weird. It literally it kicked me off.
Me
Well, I
too.
got kicked off,
me
been
too.
kicked off a couple. Actually got kicked out of a session of the Senate, and it was a Comcast problem.
Yeah.
5 of us actually got kicked out of the Senate
Hmm.
session. Luckily, the voting was all done except for adjournment, and nobody missed much. But I'd hate to have that happen during a vote on S-54, for example, a roll call. Okay, so we are now at page 17, and there's just a
Yeah,
I did not actually page 20, and I didn't understand 8 in section 2. That's at the top of page 20. Shall not use the right of self-defense to punitive.
I saw that as a statement, an explicit statement of what our understanding was when we passed 219. In other words, that even though we had a prohibited restraint, they would still have 2 means of defense under common law and the justifiable homicide statute, and now as amended later in this draft.
That's helpful.
I don't know, Bryn.
yes, so they did hear some testimony that some witnesses wanted an explicit statement that an officer's use of deadly force in self-defense would be, they would still have the right to use the defense of self-defense under the common law or the justifiable homicide defense if they used that deadly force in compliance with the standards. But you'll note that it specifically provides that that deadly force has to be in compliance with C1 through 4. And so those are the standards that are set out in C1 through 4. So it's that standard for use of deadly force in C1. And it has to be in compliance with that description of what necessary is. And also they have to be in compliance with that provision that says that law enforcement can't use deadly force on a person who's just posing a danger to themselves and not posing a danger to somebody else. And also that requirement that law enforcement has to stop using deadly force as soon as the subject surrenders or is no longer a threat. So the remainder of those provisions in subdivision C are not explicitly included in this language. And that was a decision based on the members of the committee that were working on this draft, based on some testimony, or actually some conversations that they had with various stakeholders that raised the concern that if a law enforcement officer, for example, didn't intervene, if an officer was using a prohibited restraint, or didn't follow another one of the explicit requirements under subdivision C, whether or not that person would lose their ability to raise the self-defense defense or justifiable homicide.
Thank you. Okay, now we're at page 22. This is where I think we're just opposed to this.
What section is it?
It's the one where it says
3.
they can use a prohibited restraint if they feel it's justified.
Okay.
We ban the prohibited restraint and we say it's okay to use it if it's justified. I think
Yeah.
Senator Baruth has been the long-term spokesperson for.
Yeah, no, I was glad to hear Representative Lalonde say that they would pull this.
Yep.
Section 3.
Okay, so I'll play devil's advocate. If a law enforcement is authorized to use deadly force, what difference does it make what type of deadly force is implemented?
Well, they still have the defenses that we just went over. So what we're saying is these are prohibited restraints, and elsewhere in the draft it says they won't be used for any reason. So it seems like if it says they shouldn't be used for any reason, it's schizophrenic to then say you may use them under these circumstances. With that said, if somebody is acting in preservation of their own life, they should have a legal defense. So if you pull 3, it goes back to what we did in 219, which is allow them a defense, but not create permissive language that seems to encourage that use.
Seems like a schizophrenic double-edged sword to me. If you say they have the ability to use deadly force, at the same time you're saying they may not under any circumstances use a prohibited restraint. To me, that's diametrically opposed. And I don't know what a prosecutor would do with that information. If the officer has no other available way of protecting himself and has to use something that cuts off the air supply, and yet you have a statute that says specifically they can't use anything that would cut off the air supply, how would the prosecutorial side of the equation come in on that picture? That's one of the reasons I'd love to be able to hear testimony from the Attorney General's office and from the State's Attorney's office and the Defender General about what that particular language does when an officer is subsequently looking at a potential criminal charge.
Well, I think it's a question of what, in essence, what we're highlighting and what we're not highlighting as our intent. And in terms of the prohibited restraint, I think we're making it very clear that we don't want it taught in the state and we don't want it used, but we're being realistic in allowing these defenses, which are now explicit in the House bill. So, you know, you're right, definitionally, it is a use of deadly force. But we're not saying that they don't have a defense if they use it. But we're making it very clear that our intent is that it not be used in the normal course of law enforcement.
The ultimate question is, can they use it as a defense if there's a statute that prohibits it, period?
Well,
I don't know the answer to that question. That's why I'm nervous about doing this without testimony from all sides.
But it gives them, you know, that there's that explicit section that says they have, you know, those 2 defenses, top of page 20.
I understand what you're saying, Philip, but the language specifically in a different statute removes that element, at least in my mind, initially looking at this. It removes the ability to use a prohibited restraint if in fact they're trying to raise justifiable homicide as a defense.
Well, let's ask
If I could ask Bryn to, if she's willing and able, to summarize testimony that may have been provided on this section.
So they heard a lot of testimony on this section from various witnesses. Some witnesses were in support of the bill as it came over from the Senate. And some witnesses requested that there be explicit language in here about the defenses for just the reason that Senator Benning is raising. That it was law enforcement was concerned that with the explicit language in the standards that provides that a prohibited restraint shall not be used for any reason, that law enforcement may feel the need to resort to using their firearm or some other sort of deadly force as opposed to using a maneuver that would be a prohibited restraint. And so I believe that the intent of the House was to add that language that specifically refers to the defenses that are available for law enforcement, to make it clear that if a law enforcement officer was grappling or in a struggle, and the only thing they could do to save their own life was to use a prohibited restraint, that those were circumstances where it would be allowed.
I think we did hear testimony on that from Mr. Was it Bloom from the criminal justice training, from the police academy. I believe I was on the road when he testified, but I do remember that testimony.
Yeah.
Mm-hmm. Senator White and Senator anybody.
So it is very interesting that we are prohibiting this this maneuver, we are not allowing any training to be held around it. And yet, if that's the only thing available to an officer, they can do it, but they have to do it without training because so they won't know the way to do it. I don't want to say safely, but the way to do it with the least consequences. So deadly force is the use of a gun, but we do training on that. And so it's just, I am not comfortable with whether we've come to some kind of a conclusion on this, because I think that there are circumstances where they would want to use it, but yet it is specifically, as Joe pointed out, prohibited. So we're saying this is something you can't ever use and you can't ever be trained on, but if the circumstances warrant it, you can use it.
No, we're not saying you can use it. That's what this draft is saying, and I think that's extremely confusing.
Yeah.
So if we pull out section 3, what it's saying is it's a prohibited restraint as passed in 219. You're not to use it. If a situation occurs that it's life or death, you do have a defense, but we don't have language where we're saying go ahead and use it. And that's what I like least about the House version, is that permissive language, because they have the defense anyway. But, I thought what we did in 219 was the right thing, which is don't teach it. Don't teach police that it's okay to use it. Don't think of it as a tool in the toolbox. All of the ways that they've now been taught to look at it. The idea that you're going to put your arm around somebody's throat and choke them till they're unconscious should not be part of what they're thinking of doing. If it winds up being a last ditch self-protective maneuver to avoid death for themselves, then they have here in the House version an explicit defense. But I don't think we should be in the business of essentially promoting it.
I don't see it as being an explicit defense, Philip, and this is the way I see it arising in a criminal trial. Officer is charged with homicide in one version or another. And in the defensive argument, the counsel for the defendant tries to elicit questions about what was happening and was there any other way to avoid this without a prohibited restraint. And the prosecutor stands up and enters an objection and says to the judge, it's not relevant. There is a statute, I don't know what the statute number would be at the time, but there's a statute that prohibits this maneuver specifically. So it's not authorized to be available for a justifiable homicide argument.
But Joe,
and the judge has to make a ruling. And I don't know what the judge would rule in that particular situation.
No, but the defense, as you well know, the defense would go immediately to page 20, section 8, where it says explicitly, a law enforcement officer shall not lose the right to self-defense pursuant if they've acted within those standards. So, Bryn, if I could just ask quickly, when it says you shall not lose the defense, in practical terms, it's notwithstanding the prohibition on using it if it comes under that shall not lose defense section. Is that?
Yes, that is how I read that as well.
Right. So a judge is not going to stick with the line that says it's prohibited for any reason. The judge is going to look at that next to the segment in this draft that gives the specific defense anyway.
I guess I'm coming back to their language sounding better and clearer to me, because it cannot be used unless the triggering device of being able to use deadly force is there.
Okay, maybe we're misunderstanding each other. I support page 20, section 8 of the House bill, which is and I tried to say that when I said, it seems to me to put in express terms our understanding and agreement when we did 219.
Yeah.
So I support that. Is that what we're arguing over? Is that you think I'm not?
Well, let me go back to I want it to be very clear for somebody who is in that situation to not have to find themselves in front of a jury making the argument that I'm now looking for. So deadly force means any use of force that creates a substantial risk of causing death or serious bodily injury. Bryn, you're saying that your reading of that means they could make an argument that the use of a chokehold is acceptable. Is that what I hear you saying?
Yeah, if it falls within the standards set out in C1 through 4, which are those standards for the use of deadly force, which requires that it be necessary, proportional, reasonable, and only under those circumstances that are listed in your supplement.
See, I looked at the House language as being very clear in explaining that that maneuver was only acceptable if they were first authorized to use deadly force. If you strike that language from what we're trying to do, it seems to me you're still subjecting the defendant in a criminal case to a legal argument that a statute exists that specifically prohibits this maneuver.
It prohibits it in any case, Joe, except page 20, section 8, specifically gives them the right to use it in self-defense, and then it cites the justifiable homicide statute. So if it is judged after the fact to have been reasonable, proportional, etc., and in self-defense, then they're fine.
And
But in any other, yeah, go ahead.
Thing, which is why it doesn't refer to C8. It refers to C1 through 4. So it doesn't, it means that they don't have to be in compliance with the requirement that, I'm sorry, C6, that a law enforcement officer shall not use a prohibited restraint.
Oh. Okay, I get it.
Yeah, I get it now. It's a torturous way of getting there, but I get it now.
I did, yeah. I do have another suggestion. I don't know if now is the time to float it. But one way that may be easier to reach this, the same place that you're at now, is by amending the language in the justifiable homicide statute, subdivision 3, to refer explicitly to those 2 sections of the new standards that set out the standard for use of force and use of deadly force. So it would refer, instead of to the whole statute, the whole new standard statute, which is 2368, it would refer to specifically B2, which sets out the standard for law enforcement use of force, and section C1, which is the standard for use of deadly force. And that way you would be excluding all of those additional factors in the standards, including the prohibited restraint.
Yeah, I'd agree with that.
I'd have to see that. It's a little confusing to try to figure out the interaction. So you are suggesting, Bryn, to do that and then to take out other pieces?
I think, I'm just hearing the committee kind of grapple with that subdivision C8 as being confusing. And so I'm floating another idea, which may be, instead of including that language in C8, you change the language in the justifiable homicide statute. So it provides that law enforcement can raise that justifiable homicide defense if they use force or deadly force in compliance with those specific sections of the standards on law enforcement use of force, meaning C1 and B2. So you would be excluding the other requirements, including the language about prohibited restraint. Do you see what I'm saying? So it wouldn't.
I do.
Officer would essentially be able to raise that defense even if they weren't in compliance with the prohibited restraint language.
Yeah,
Philip, I understand you're having the same problem I am from the other side, and that is that the design of this language is still problematic. And if we ourselves can't understand it, that has me really concerned. The other part of this is we're dealing with this discussion in a vacuum because the House is still working on changes. And I have no idea what they'll end up with.
yeah. No, I think from this walkthrough, it's clear to me that we could get to a bill. I believe we could get to a bill that we agree on. It's dependent on, does the House stick with what they've got here, or do they hand us a new fourth draft 2 days from now?
Yeah.
Right. Okay, let's, since we've got about 5 minutes left, so 10 minutes at the most. I think we're getting to a place where I'm comfortable with parts of the bill, but not all of it. And so I think we need to move on. They make an effective date of September 1st, 2021 for the section on the use of force. Is that correct?
That's correct, but I would say that that's probably due to the section 1 that it sounds like might be coming out because
okay.
it's intended to give law enforcement
Yeah.
time to come up with their own policy.
Okay. All right. In preparation for tomorrow's meeting, can you look up what Washington state law is?
Certainly, I can send that to Peggy. They've got several statutes relating to the use of force. I can just include all of the ones that seem most relevant.
Okay. Because it's all very confusing, but it's really not as confusing as it seems. Does that make sense? We're doing our best to comply. It may fail, may not work, but I haven't thrown it out yet. So we'll look forward to tomorrow's meeting. And
Well, we'll be there. Whether we look forward to it or not is a different question.
better way to put it, I guess. So
So-
we'll see you all at 1.
Dick, before we sign off, can I just talk to you for a second about the emails we've been getting?
Yes.
About
You want to do that while we're live?
No.
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 Okay.